to believe that the assets of the debtor are in a specified, we'll say, bank account that can be garnished. I mean, that's the CPF Aseo case. I understand it's an unpublished decision, but that is at least analogous in that the bank in that instance put forth a litany of accounts that it thought were held assets that they could garnish, and while the trial court in that instance granted it as to some bank accounts where the witness provided testimony that there was a good basis to believe that, and he denied it for others. And in this instance, there's no testimony about any specific accounts that need to be garnished. And furthermore, I think the trial court's order is cognizant of that fact. His reasoning, and I think his heart is in the right place, was, hey, that is a problem, but what we'll do is we'll fix it after the fact, and you guys provide some paperwork, identify some specific assets, and we can do it. And I think fundamentally what we have is that's just not compliant with the statutory scheme that's been set up here. And I don't think, or I guess I would articulate that the legislative prerogative and the public policy behind the provisional remedy statute, protection of constitutional due process, and ensuring that the procedures aren't abused, it doesn't really provide a lot of room for deviating from the statutory requirements with judicial exceptions. And that is not uncommon in Arizona case law. We've got Deer Valley Unified School District v. Hauser with respect to notice of claims filing, needing to file within the statutory deadlines, specific amounts. This court in prior opinions has been very clear. A general amount won't do. You've got to be specific. Recently, although not an Arizona case, but the Ninth Circuit in Mia v. Hobbs was discussing the requirements for verification in a special action, noting that the petition for special action in election matters has to be verified, and that's not something that can be excused. That case is not discussed in our briefs or pleadings. It came to our attention after the fact, but those types of statutory requirements, I think, underscore and emphasize why in this instance the validity of the ultimate order itself fails simply because at the outset there was no compliance with the statutory scheme. I will continue. The other aspect that we'll get to is the notion that a provisional remedy can issue when there's no security or a debt is undersecured. In this instance, yes, there is testimony that there's no dispute that the bank has a first priority lien that's fully secured in the bankruptcy. They filed a proof of claim. There's a settlement agreement. The testimony in front of the trial...
Back up. What do you mean it's fully secured in the bankruptcy?
Well, I mean, yes, I mean what it says.
Fully secured by what?
Well, it's fully secured both by we'll call it the tangible assets remaining in the company, and I'll address that, but also the claims that are being pursued by the bankruptcy trustee. And those claims that are being pursued for fraudulent, I think, conveyance, relate directly to Pure Khana's use of the loan proceeds at issue in this case, deviating from the loan agreement. The loan agreement required that the loan proceeds that they provided to Pure Khana be used for certain limited purposes.
But Jill agreed, just because the bankruptcy proceeding exists, it does not supplant, it doesn't take precedence or preclude this type of procedure that the respondents are seeking here, does it?
Well, no, and I don't believe that we've argued that the existence of the bankruptcy precludes their ability
So what you're saying is that there's plenty of assets in the bankruptcy proceeding, so is that what you're arguing?
Well, no, I'm not arguing. I think the argument is that the evidence put before the trial court at the provisional remedies hearing wasn't sufficient to reach a reasonable conclusion that the funds that the debt was undersecured in this instance. There was testimony that the value of tangible assets remaining was $250,000 in comparison to a $10 million loan. Nobody's going to argue that that wouldn't be undersecured, but there's a different component to this, which is what I was speaking about prior to your question, and circle back to it, which is there are valuable claims that the bankruptcy trustee is pursuing. There's a settlement agreement that Westtown brokered with the bankruptcy trustee to have a first priority lien fully secured. And part of that is the claims being pursued by the bankruptcy trustee against Pure Kana for what is effectively misuse of the loan proceeds. Now, we're talking about a publicly traded company. We're talking about millions in loan proceeds that were, as I understand the claims in the bankruptcy case, fraudulently used or conveyed in derogation of the loan agreement, and frankly other facts that are beyond me right now. But the notion that those don't have value, that those aren't security, was not addressed. And that evidence was directly before the trial court. It's Exhibit M and N in the appendix, page 482, allows the trustee to pursue recovery of assets for the benefit of not only the bankruptcy estate, but Westtown. And I think the point here, I wouldn't even call it a nuance, is that yes, we can focus on the testimony that there's only $250,000 in hard assets, but there's evidence before the court saying there are these claims, and there's no evidence about the value of those claims submitted by Westtown at the hearing. And I think from a practical standpoint, I guess what I'd like to address before reserving some time for rebuttal is 2 points, which is what are we really looking for and what's the practical result, which is simply vacating the order. Our contention is that because it was flawed at filing, it's just simply to vacate the order regarding the provisional remedies granted and the prejudgment discovery. There doesn't need to be another hearing. If Westtown wants to go that route again at this time, I suppose they can file another application that's verified and comply with the statutory requirements. So that's what we're seeking. That's what we think the practical effect of this would be. Separately, turning to the prejudgment discovery, without being too redundant or derivative, I mean, it ties back into all of the arguments that are in the pleadings and that I've talked about today, which is the prejudgment discovery permitted only makes sense if the provisional remedies should have been granted in the first instance and there's a basis for it. But our argument here is that even in this instance, it's an invasion of privacy and, frankly, not clearly one that is set forth in Rule 69 and 64. And I think the only other point I would like to return to is one emphasized in the beginning, effectively this notion that there is harmless error or that the judge was able to cure the error through the hearing procedures just doesn't work in terms of the statutory scheme and the compliance requirements. And I would just return back to citing Deer Valley v. Hauser and Mia Familia v. Hobbs. And I'd like to reserve the rest of my time for rebuttal. Thank you.
Good afternoon, Your Honors. Timothy Watson, Provident Law Firm, representing Respondent Westtown. I would just like to first touch on a point that was raised by the court concerning the affidavit or verification to this provisional remedy application. First of all, the respondent does not concede that it was tardy or deficient in any respect. However, with regard to what counsel said, the statute, specifically 12-1526, is clear. That language says, after compliance with the provisions of this chapter, and quote, upon the execution and filing of the affidavit and bond, the Superior Court judge or justice of the peace shall immediately issue a writ of attachment, unquote. It doesn't say might issue or may issue. It says after compliance and the filing of the verification shall issue, presumably after the remainder of the provisional remedy requirements are satisfied. In this case, as we pointed out in the supplemental appendix filed for the court, excuse me, the verification in this case, not to the complaint, but to the provisional remedy application itself, was filed not only before issuance of the writ, it was filed before probable validity hearing, at which the respondent's witnesses could be cross-examined on it.
Before we get to the hearing, yes. We did receive the verification to the application, which was submitted after the stay hearing. We appreciate that. It's a very conclusory allegation, correct? It says that I, Mr. Crawford, am a representative of Westtown, doesn't say what his position is. I've read the application, and to the best of my knowledge, it's true. Well, there's no information that would indicate he has any personal knowledge of any of the matters set forth in the application. Does this verification satisfy the statutory requirement that the applicant show that one of the grounds for attachment exists?
Your Honor, under ARS 12-1526, I would say absolutely yes, because it verifies the contents of the provisional remedy application itself, which is in the appendix filed to the merits briefs. And as Your Honor will see, that provisional remedy application was quite detailed. It set forth the loan agreement, the guarantee, the security agreement, and all aspects of that loan that was guaranteed by the petitioners, Alt and Yauck, and the reasons, the basis for it, and the basis for recovery.
The application doesn't identify any garnishee. Isn't that required for a writ of garnishment?
No, I don't believe so, Your Honor, because, first of all, I should clarify, the Superior Court has not yet issued writ of garnishment, only writ of execution. However, if the Superior Court had issued writ of garnishment, that has always been a part of the prejudgment remedies, and I would say the statute has to be read in conjunction with both Rule 69C1, which says, in aid of the judgment or execution, quote, may obtain discovery from any person, including the judgment debtor, unquote, which then allows the provisional remedy applicant upon issuance to actually identify assets that could be recovered. It would be highly unusual if a provisional remedy applicant would know, well, I shouldn't say that. There are cases where assets to be garnished or executed upon are known and are identified. But there are often cases where that's not the case, and they must be identified, as in this case, where the petitioners have assets that need to be identified in discovery in order to seize or execute on them in aid of the provisional remedy granted. I would also point out Rule 64A, which says the remedies generally, at the commencement of and throughout an action, every remedy authorized by law is available for the seizure of a person or property to secure satisfaction of a potential judgment.
And it says attachment and garnishment. It lists the...
It does, Your Honor. That's right.
It does not say discovery.
No, that is a separate issue. But as to Rule 64B3, it does include both, it includes garnishment and attachment specifically.
Right, but it doesn't say you can conduct discovery in support of an application for garnishment or attachment. It just says you can pursue garnishment or attachment.
Under Rule 64 A and B, you're correct, Your Honor. But I would say Rule 69C1 clearly says obtain discovery from any person, including a judgment debtor.
Let me ask you about the probable validity hearing. One of the purposes of the hearing is not only to require the creditor to establish the probable validity of its claims, but also to give the debtor a chance to establish any claims of personal property exemptions. In your application, you didn't identify any property that you were seeking to garnish. So how can they establish exemptions for property if the property hasn't been identified?
Correct, Your Honor. Once writ of execution is issued, in order to execute the writ, there are statutory protections such as the exemptions you're talking about, homestead exemption, personalty exemption. It is illegal to execute upon those assets to the extent that the statute prohibits it. That's an additional protection built in for the debtors, in this case petitioners, Alt and Yauck, such that a creditor could not attach those. If I execute on real property, the sheriff will not let Westtown execute beyond those exemptions.
Okay, but the debtor is supposed to have the right to establish exemptions at a hearing, at the probable validity hearing, right?
Well, conceivably they could, Your Honor, establish those defenses.
But they didn't have that opportunity here because no property was identified.
Well, there's no real need to establish that. That's kind of putting the cart before the horse in this case, Your Honor, because once those assets are identified, the debtor can always raise those exemptions. That is always a defense by statute.
How? The hearing's already been held. It's over.
In order to execute, Your Honor, as I said, the writ has to issue, it has to be served and executed upon, and if there was a question about whether an exemption has been violated, the Superior Court can always enforce those exemptions, always, by statute.
So the debtor would have to come back later and say that this garnishment was improperly executed.
Procedurally, that's correct, Your Honor. However, it is not unusual to have a provisional remedy application that does not cite a specific asset or tangible property to seize because it may not be known to the creditor at that time. It's analogous to a post-judgment situation where that could be the case there too.
All right, let me ask you about something else, about your application that you filed in the Superior Court. It says on page 8, as it is possible that the plaintiff may never prevail in its case, it makes no sense to waste the time and resources of the party and their counsel dealing with issues about assets to enforce the plaintiff's judgment until there's been entry of judgment. So is it your position that you should be allowed to take financial discovery to see if it's worth your while to continue pursuing this lawsuit?
No, I think what we're saying, Your Honor, is that it's important to permit discovery in aid of the provisional remedy granted so that the assets of the debtors, the petitioners in this case, can be identified and Westtown can discern whether pursuit of the provision, how to pursue the provisional remedy that's been granted properly. And also, Your Honor, the probability of recovery on the merits case below. That is, on the merits of the claim against debtors on the guarantee. So there is an aspect of that as well, to know at this point, once the provisional remedy is granted, is there a possibility of recovery on both the provisional remedy and on the claim on the merits for the guarantee?
Well, plaintiffs are generally not allowed to conduct discovery to see if it's worthwhile to continue the lawsuit.
Correct, Your Honor.
This is different.
It is different, Your Honor, because this is a some certain liquidated sum being sought and the provisional remedy has been granted. I would agree with you in the normal circumstance, a plaintiff would not be permitted to engage in prejudgment asset discovery absent punitive damage claim or something along those lines. But this is a different case. I would just point out, with regard to the argument about the security for this loan and guarantee and all of these red herring issues about a bankruptcy proceeding, I can address that right now. First of all, Westtown's witness had sufficient foundation as the vice president of the bank and the officer with personal knowledge of the loan at issue, as testified to in the transcript submitted in the appendix to the merits briefs, that this loan is not now and has never been fully secured or even close to being secured. It is unsecured or at a severe level undersecured. At best, the nature of these security assets on the security schedule attached to the loan agreement and these guarantees, and on which this loan and guarantee was predicated, listed at their best $200,000 or so in security for a $10 million loan. It was severely undersecured then, and it's even more undersecured now because the witness gave undisputed testimony, not contested testimony, undisputed testimony, that these peculiar assets, these CBD-type products that we've described in the merits brief, are diminishing in value constantly. So there is far less security even than there was at a loan origination. And I would just say also, with regard to the grounds for this special action, under the old Rule 1 and what I guess is now Rule 2B2, we've added in the briefs argument about there being no basis for special action jurisdiction unless they can show there is no equally plain speedy remedy at law. There is an equally plain speedy remedy at law here. It is money damages. If Westtown in the court below were to fail in its claim on the merits, the petitioners here are protected by a bond, as I pointed out during the stay hearing argument. There is no equivalent protection for the creditor, Westtown, at this point in time. Right now, the only party that's protected by a bond are the debtor petitioners. I would also say, with regard to likelihood of success on the merits, the old Rule 3 and what I guess is now Rule 4B or C, there should be a showing of the court below acting without or in excess of jurisdiction. That's clearly not the case here. The lengthy minute entry that the Superior Court, Judge Fox, issued clearly cites the statutes under which he granted provisional remedy, the rules in conjunction with the statutes under which he granted prejudgment asset discovery, and there was no excess of jurisdiction.
If it's later determined that the garnishment, the attachment was improper, that's a due process violation, correct?
Well, not necessarily, Your Honor. They've had full due process. It would be an error of substantive law, not an error in due process, because they did have a probable validity hearing and provisional remedy granted.
But hasn't our U.S. Supreme Court said even a temporary deprivation of property violates the 14th Amendment?
Well, but Your Honor, it's an execution of an order of the court that was duly rendered after after compliance with the statutory provisions. That's different from an out of jurisdiction or in excess of jurisdiction seizure of property. I think there's a distinction there. So I don't think that's the case here. I think the procedural hurdles have all been met. It would be a question of whether Westtown in the Superior Court failed on its claim on the merits, in which case the petitioners, Alt and Yauck, are protected by their bond.
Well, what if we decide after trial, after an appeal, that the judge didn't follow the proper statutory procedure? Then we found that there's been a due process violation, correct?
I'm sorry, are you saying after 54C judgment, Your Honor?
Yes.
Okay, so after 54C judgment, petitioners would then file a normal appeal.
Right.
And I don't think that there would be a procedural deprivation. It would simply be a claim of error in the court below on that 54C judgment.
Well, the error would be that the court erred in issuing the provisional remedies at the outset of the case. If we wait until the end of the case in a normal appeal to decide whether the property was properly taken and we say, no, it wasn't properly seized, Well, then we found that there was a due process violation. How could a post-judgment appeal remedy that?
Yeah, I think, Your Honor, the due process is satisfied by the provisions of 12-2404 and 12-1526. I think that substantively, if there was a claim of error, that is properly addressed on appeal from a Rule 54C judgment. I don't think it's necessary to have a special action to determine that up front because the procedural safeguards have been satisfied. It's a claim of substantive error.
What if we find that the procedural safeguards were not satisfied? Then a post-judgment appeal is not an adequate remedy.
Yeah, I see your point, Your Honor. I think here, there's no question. The application was filed with verification before even the probable validity hearing.
With a completely conclusory verification that tells the reader nothing, correct?
Well, no, Your Honor. It verifies a lengthy application that does cite to all of the provisions in the loan, the guarantee, the security agreement, and the bases for the provisional remedy issuance. And the sum certain, too, by the way.
The verification tells us nothing except Mr. Crawford's name, and that he sincerely believes the application is true. That's what it tells us.
But critically, Your Honor, I think it says it is within his personal knowledge and observation, as he testified to at the hearing, as set forth in the transcripts attached to the merits briefs here in the appendix.
So you're saying the probable validity hearing testimony cures any default or defect that may have existed in the application?
Well, I don't concede there was a defect, but it certainly would. And he was subject to cross-examination. And I would add also that after the cross-examination of Mr. Crawford, petitioners did not present testimony of their own. They did not seek some type of defense. They did not seek some type of exemption. They simply rested.
Well, they couldn't seek an exemption because no property had been identified.
Well, but they do have a security agreement that lists some personal assets as set forth in the papers. There was a list of personal assets that they did submit, but there are other assets we are seeking to execute upon as well.
Their financial statement, is that what you're
That's
referring
correct.
to?
A financial statement, yes, Your Honor.
It doesn't identify any particular bank account.
No, it doesn't. It doesn't say specific bank account numbers. That's true. So I would just say, with the brief time I have remaining, with regard to the argument in the briefs about this double recovery, that argument, I still don't see how there's a good faith basis for that argument. The terms of the loan and the guarantee do not allow it. The loan, the security agreement, and the guarantee specifically say, quote, principal, premiums, and interest, unquote. It also says the loan is terminated upon satisfaction. You can only recover a loan on a loan once. That's very basic contract interpretation. And if Westtown did try to collect twice, once in the bankruptcy court and once here in the Superior Court against the guarantee, the petitioners would have a cause against the bank in the Superior Court. There's no question. So that argument I don't even see has any legitimate basis. And finally, I would just say, if the court is well, let me back up. First of all, therefore, we request that the court affirm the Superior Court order, affirm the provisional remedy and the prejudgment discovery in aid of that provisional remedy. And I would also say, if the court is inclined to stay the provisional remedy and disallow prejudgment asset discovery, we request that the petitioners be required to post a supersedious bond pursuant to RCAP 7A1A. And if the court has any other questions, I'd be happy to answer them. Thank you very much. Thank you.
Thank you. I'd like to address one thing. I talked about it before, but I think it's worth following up on. And it's Appendix N. I think I said M earlier. Appendix N, 483. It's the settlement agreement entered about 2 weeks before the provisional remedies hearing, October 10, 2024. Westtown shall be deemed a valid, duly perfected, and unavoidable first priority lien on the assets, and the Westtown claim shall be allowed as a secured claim in the amount of $10,200,000. I don't know any other way to say that it's fully secured. I understand the arguments, but I don't think it's fair or reasonable to suggest that that to the extent there may not be tangible assets or claims, it's not a secured claim in the bankruptcy. The other point that I would like to address is I think there is a tendency with the provisional remedy statutes to get confused with the normal non-provisional remedy attachment and garnishment proceedings. I mean, there's a huge difference in perspective and policy rationale when somebody has gone through trial and gotten a judgment on the merits of the decision and then seeks to execute on that judgment versus the provisional remedy situation where somebody is coming into court and saying, before we get to execute, so before I prove the merits, before they've been fully adjudicated, I would like you to accept probably, I'm going to get there one day, and in the interim, I'd like to collect all the assets that I can from the defendant. Different policy rationales in both instances, I think, emphasize why the requirements in 12-15-26 just can't be used as a stand-in for the specific requirements in the provisional remedy section in 12-24-04. Those are safeguards. We can all imagine situations where somebody, creditors start filing unverified applications to just see where things go and make efforts to then, I guess, try and cure the defect or get to the provisional remedy hearing and then try and put a witness on to do it. But I think that's why they have the safeguards, is to prevent that type of abuse. And then finally, with respect to, I think we've made a request for attorney's fees, and I think in this instance that we'd articulated that if you agree with us that there was not the necessary strict compliance with the statutory provisions, then I think the special action is very justified on that basis and ground. And unless the court has further questions or I can provide some clarification on any of those points, I'll rest.
No question.
Thank you very much.
Counsel, we thank you both for your arguments this afternoon. This matter is under advisement, and we'll issue our decision in due course.